Are you looking to grow revenues, increase profitability, or obtain financing? If so, you came to the right place.
Running a business is all about leadership. How do you become a better leader? Learn from the successful entrepreneurs and business owners how to lead your organization more effectively. That's why we created Leadership Live at 8:05, Talking Small Business, to help you succeed with your host, Andrew Frazier, Business Growth Pro and CFO and founder of the Small Business Pro University. Every Tuesday evening at 8 p.m. Eastern, we're joined by experienced entrepreneurs and business owners who share their secrets to success via live stream. Also, every Friday morning, we release a new podcast episode. Either way, you will learn about developing your business leadership skills from our roster of highly performing guest experts. Leadership Live is one of the many valuable resources provided through the Small Business Pro University, empowering business owners to learn, profit, and grow. Find out more at sbpro.u.com.
Good evening and welcome back to Leadership Live at 8:05. I'm your host, Andrew Frazier, and thanks again for joining me once again on Tuesday night. We're here, to really share some expertise. We created Leadership Live to really help entrepreneurs and small business owners further develop their leadership skills by learning from other leaders. In business, there's so many things that you need to know that it's impossible to know them all. But your business can only go as far as you're prepared to lead it. So it's important for you to continually learn, continually develop your leadership skills. So this is just one way that you can do it. So each week we have a great guest and a great topic that can help you be more successful in business. And today is we're really going to be talking about a couple things that a lot of times business owners overlook or assume that they aren't that big of a deal until they become a big deal. So we just want you to sort of think about them and better understand them, because there's also misinformation around it. Everybody's heard of copyrights, patents, trademarks. What are these things? How do they work? We had a great session on trademarks. And today we're going to talk about patents and we're going to talk about copyrights, because each of those is important part of your intellectual property, and they need to be protected. So tonight I'm going to be talking to Benjamin Dach. We're going to talk about how to protect your business assets using both copyrights and patents. So look forward to having a lively conversation. As always, feel free to put something in the chat, put a question, comment, and let's get started. Let me bring Benjamin on. Hey, Benjamin, how you doing this evening?
Hey, Andrew. Good. How are you? How are you tonight?
Excellent. Thanks for taking the time out to hang out tonight and share some of your expertise.
Absolutely. I'm happy to be here. I'm grateful. Thank you.
Okay, excellent. So, we're just going to hang out a little bit, loosen our collar, have some fun, and definitely, we know each other, but the audience doesn't know you. So if you could take a few minutes to sort of just chat a little bit about, your journey, how did you get to where you're doing now and what are you doing now? And then, once we do that, we'll be ready to dig in and take a look at where things go from there.
Sure, Andrew. Yes. So my journey really began back when I was in college. I was studying chemistry, and I began researching chemistry in depth. So I decided to pursue a graduate degree in chemistry, just keep going and learning more and more about science. I've always loved math and science, always been a forte of mine. So I pursued my chemistry bachelor's degree and then a graduate degree, a Ph.D. And it was just great. So much knowledge and chemistry to be obtained. And during that time, I decided to through the university, apply for a patent of my own on my own work. And when I did that, I learned about the patent system. I learned what it was about, how it worked, and I actually interned at my university, Columbia University, to work in the technology transfer office and help them with other intellectual property pursuits and monetizing their intellectual property as well. So it really opened up the door for me to learn about the field of intellectual property in general, which would cover copyrights, trademarks, and patents. All three of them fall under the umbrella of IP, intellectual property. So I had the benefit of asking a professor there to audit a patent law class, and I sat through the class and just kind of absorbed the information. And from that point on, when I got my Ph.D. in 2012, I got a job in Manhattan working at a boutique patent law firm, which was really an intellectual property law firm that doing all sorts of IP law. It was called Frommer, Lawrence and Haug. And I started off there as a scientific advisor. And my main task was to help with high level pharmaceutical patent litigation. So from that point on, in addition to other patent work, I assisted with helping brand name pharmaceutical companies assert their patents against generic pharmaceutical companies. And I used my chemistry background to help me with all of the chemistry know-how and scientific technical expertise to assist. So it was a combination of science and law. And then the third component would be business. And I've been picking up that component as I go along with my work experience. From then, my journey took me to a different law firm, Quinn Emanuel, where I focused heavily on patent litigation, and also I expanded my practice into other areas like arbitration, and then I moved on to another firm and did additional work in the patent litigation space. And I kind of kept growing and expanding my horizons outward, doing more patent work, doing trademark work, doing copyright work. And at my last firm, I was involved in a copyright litigation, a pretty exciting one involving a major show on a pretty major platform. So it's always interesting when the work has an effect that has major ramifications that affect lots of people. So I've had the privilege and joy of working on big cases that have had major impacts as well in the legal field. Now I work for a small intellectual property firm called Weiss and Ahrens. We are a small, about 7 attorneys, 7 patent agents, and 4 PhDs in various fields of science. I'm a chemist. We have a materials and a physicist and a computer scientist, different areas of science. And the way it works in patent law is usually the patent attorney will be a sort of an expert in one field of science, maybe in the life sciences or the material sciences, or also the electrical engineering and computer end of things. And then you bring it all together by drafting patent applications, filing them for clients, drafting trademarks, assisting clients with their copyright issues and the like. So really at this point, we do all sorts of intellectual property work, ranging from a patent prosecution, which means drafting the patents and filing them, to more counseling types of work where we can assist people who have issues navigating the patent field. And then finally, there's litigation, which is sort of when you have the patent, when you have the copyright or trademark, and you want to assert that against a potential infringer. And these are the typical areas of law, and I'm experienced in all of them. So I'm really grateful to be here and share my journey with you, Andrew. It's really a pleasure to be here with you. Thank you.
Okay, great. Thanks, Benjamin. I'm excited to have you here as well. Definitely look forward to digging into sort of a little bit more about what you're doing, what you've done, and there's your website as well as your profiles available. So people who want to learn a little bit more about you or connect with you, the info's right in the chat, so feel free to do that. Benjamin's a friendly guy, so he welcomes you to reach out and say hi. So I always like to start at the beginning. So, we got to break it down to the basics. So what is a patent? What is a trademark? What is a copyright? And what are the differences? What are the differences between each of those?
Sure, Andrew. And so a copyright, we'll start with copyright, sort of the most common form of intellectual property. It protects original works of authorship. So really, copyrights are for creative works of expression, music, film, paintings, software, books, things that you really want to protect a creative expression. Trademarks, taking it a little bit more narrow, are geared towards protecting a logo or a trade name, which is really designed to prevent consumer confusion. So if you think of a trade name of a product and you associate that name with a logo, I think very typically of like something like Coca-Cola. There's a trademark and a trade name, and you associate that logo with that product. That's a trademark. It protects the business, it protects the consumer. Then the patent, just a little bit more narrow on the intellectual property window, it focuses on inventions. So it protects an invention, an innovative specifically an invention, a method of manufacture, a method of use, or an article that may have been invented, a machine or an object that was invented that has a useful nature. And for patents to be patentable, in order for the invention to be protected, it has to meet a few criteria. The main ones being that it just has to be novel, new, and not obvious. And we can go into all of that in more detail. But when you can prove that you've made something useful, novel, and non-obvious, the patent office will grant you a patent for that innovation. And it's supposed to protect the idea of innovation. It's supposed to make the marketplace more strong and robust, make products more useful, and human ingenuity is just the sky's the limit, right? So these laws have been in place really, and they're deep in the U.S. Constitution as well. So they're a part of our law system for hundreds of years. Sure, the legal system has developed, especially recently with more recent technologies that we have to grapple with. But these foundational principles are fairly old, and they go back hundreds of years. And so we are benefiting from these ideas because now we can protect amazing works of art that so it inspires people to make the best art that they can make. It inspires people to create the best products, to avoid consumer confusion. It protects the marketplace. It protects the consumer. They know what they're getting when they purchase something at the store. And then it also protects the innovation system such that people can rely on technology constantly improving, because there is an incentive built into the market that rewards creativity and intellectual property, especially inventions. So I'm happy to dive into each piece and component, but that's in a broad overview, that's what copyrights, trademarks, and patents are, and how they work to protect both the consumer, the marketplace, and also the innovator.
Okay, excellent. No, that's a great, clear, concise explanation. That's probably the clearest, most concise explanation I've heard so far. So,
Okay.
obviously, you know what you're talking about. So, so definitely, we're going to dig in and take a look. We're going to spend more time on looking at copyrights and patents. But for comments and questions, if there's certain things you want to know about, feel free to put it in the chat or whatever, and we'll try and address them while we're here. Let's take advantage of Benjamin being here. And but before we get too far, what I want to do is take a second. We do the show and a lot of other initiatives for entrepreneurs and business owners through the Small Business Pro University. So we'll just take a second to see a short video about what the Small Business Pro University is all about. And we'll be back talking small business with Benjamin Dach. Many small businesses experience low or no revenue growth, and the owners are not making enough money. I founded the Small Business Pro University to help business owners break that cycle by empowering them with greater knowledge and enhanced skills to lead their companies more effectively. Over the past 15 years, I've worked one-on-one with more than 1,000 business owners and taught tens of thousands of people about business. My experience includes serving as a Navy officer, graduating from MIT, earning an MBA from NYU, and achieving the CFA designation. Small Business Pro University empowers entrepreneurs like you to run their businesses more professionally and create sustainable enterprises. Small Business Pro University provides access to valuable resources, partnerships, and relationships that will help you to grow revenue, increase profit, and obtain financing faster and easier. Our Masterpreneur initiatives include more than 100 expert-led multimedia courses and training programs with more than 2,500 lessons. The Small Business Pro Network, our private community for entrepreneurs. Leadership Live at 8:05, Talking Small Business, our weekly live stream and podcast. Advanced Learning Institutes focused on revenue generation, profit maximization, and capital acquisition. And the Power Breakfast series, in-person events where business owners learn best practices, enjoy great networking, and gain useful knowledge. If you want to sell more and make more, you need to check out Small Business Pro University. Visit our website at www.sbprou.com. Okay, welcome back. I'm here with Benjamin Dach, talking small business, and let's get started with copyrights. You talked about copyrights. Basically, everybody has something copyrightable, but does that mean we should copyright it? And how does a copyright work? What should we copyright? What shouldn't we copyright? So let's start with is everything copyrightable, and what sort of things should we think about, copywriting or going through the copywriting process with?
Sure, Andrew. So is everything copyrightable? Well, in a way, copyright protection, it's actually automatic upon creation of a work, of an expression of original authorship. So as long as the work is original and an artistic expression of some sort, it's copyrightable. So did that answer your question? I don't know, but it's not necessarily everything, because it has to be original, number one, and then it has to be also an expression of an artistic or a creation of some sort of an expression. Copyright protection is actually automatic upon creation of the work. So the creator, the author, does not have to register the copyright with the Copyright Office. However, registering the copyright provides legal benefits, such as the ability to sue for statutory damages and attorney's fees. So it would benefit whoever created that original work of authorship to obtain a registration for a copyright. Copyright registration is inexpensive, and authors are able to obtain registration for a small fee. One does not require anything else, really. It's very doable. However, it's not automatic. That part is not automatic. So you could have a common law copyright, which is just, it's similar. Just let's say I draft something, I write a poem, I write a book. Now I have this book that's an original work of art, an original work of expression of the mind, and it's mine. But what happens is that if somebody copies that, I'm not necessarily as protected as if I would go and register this piece of art with a date and the little C for the copyright symbol, and it grants the creator exclusive rights to reproduce, distribute, perform, display, and create derivative works based on the original. So that those are the copyright rights. It grants the creator these exclusive rights. No one else has that right. So by definition, the author can then sue for copyright infringement anyone who then takes that or reproduces that original authorship without their permission. And a copyright lasts a pretty long time too. So it generally lasts about 70 years after the life of the author. So it's a fairly long amount of time to have that protection. And it's not a very expensive way to go about doing it. So copyrights, they are, as you said, Andrew, the most common form of IP out there. It could be an algorithm. It could be the coding of your software. Nowadays we have generative AI and LLMs, and people are coding software for video games. Not only could the video game and all of the art and the expression that goes with it and the storyline, but also the coding of the software itself could be copyrighted. So there's all sorts of aspects that you can capture with copyrights. And a little caveat is that for works created for hire or anonymous works, the copyright would last from 95 years from publication or 120 years from creation, whichever is shorter. That's just a little bit of a caveat, a little asterisk on how long a copyright might last. But generally speaking, copyrights last 70 years after the author passes away. Noted in the news, the Mickey Mouse copyright for Disney World was just expired recently, and Walt Disney's has been expired for a lot longer, for over 70 years. So exactly 70 years after his death, the copyright has now expired. So that's copyright law in general. Is that, of course, what is copyrightable? It's original works of authorship that have a creative expression. And should anyone actually go through the steps of registering the copyright with the Copyright Office? That's another question. And the answer really is for a small fee, for a small amount of money, you can then get that additional protection. So for the most part, if someone who wants to monetize their expression of art, whether it be a book, a film, a painting, a piece of software, a poem, or a musical composition, one would then go ahead and obtain copyright registration for that work of expression. It's really not difficult to do. It's something that's doable online nowadays, and it's recommended, even if there's a possibility of monetizing that work or expression.
Okay. So say we didn't go through the process of registering it, but then someone copies it. What happens then? Are we protected, or are we not protected, or what should we do?
So if the copyright is not registered and it's just an automatic creation upon the work, let's say I write a book and it's a masterpiece. I put it in my shelf and I just leave it there. Somebody comes and they photocopy it, and they photocopy the whole book, and they start printing it and selling it, let's say, and it becomes the next biggest book, right? That's your classic example. So the difficulty here is going to be proving to a jury. In this case, it would likely be a jury, because these cases, copyright cases, are typically jury cases, but it could be a judge or a jury to see the evidence that exists, that the author is the true and original author, and that evidence may be difficult to obtain. Now, if you register your copyright, that's your evidence. It's all there. You have the time stamp, the date stamp. It's all there, so you know this came first in time, and you can then have a better case. However, it's definitely possible to prove that your book came first, and you copied, that you were the author of the book, and you've obtained this actual copyright without the registration. So in that case, you would have to then show, okay, evidence, I dated the book on such and such a date. Now, the evidence has to be by a preponderance of the evidence, which is more likely than not. It's not necessarily a standard that's so high, like a criminal case where it's beyond a reasonable doubt, or even some cases are clear and convincing evidence, which is even a little bit low. It's just preponderance, which means more likely than not, your book was written first and you have the copyright. However, without the sort of the timestamp, nowadays we write everything on the computer, right? So we have this metadata where you have, actually, that can provide evidence as well. So nowadays it's actually easier, if you think about it, to prove that something like that may have occurred, that the author was sort of the original author. They wrote the book first, and then the draft was stolen. And as I mentioned, there are actually copyright cases. I've worked on one, a pretty high profile case. It was in the news. It involved a major TV show that's watched by millions of people. I would mention the name, but I'm trying to stay away from too many specific details, just out of attorney-client privilege and all that. But I'm happy to talk about that too, by the way. But the point is that there was an example exactly of what you said, in fact, where somebody said, "Hey, I wrote this play, or it was a screenplay, or some kind of could have been a book, whatever they wrote, right?" And then somebody, the argument is, kind of knocked off the idea or ripped off the idea, right? Which is by the way, that's a whole other kind of gray area of copyright law, which is, well, what's considered copying and what's called fair use in the field, which, okay, that's another aspect of it. But the point being that one would have to then prove through evidence that they were the original author, and that their work was indeed copied illegally.
Okay. So then, even if you're not registered, you can go to court. Now, can you register after the fact? Is that a problem, or?
You can register your copyright after the fact. It's not a problem. There's no statutory limit in terms of timing. And that's a great question, because as opposed to patent law, where you have 1 year basically to get that patent. There's a year grace period from when you might have publicly just shared the idea or even sold the product or anything. You then have 1 year to then obtain a patent on that. Whereas copyright, you could register your copyright years later. The issue would be that if anyone else came up with that copyright, or it would then kind of make it a question whether, you were the original author at that point. It would just be like what we call like a race to the copyright office, So if the work is not original, then it's not going to be copyrightable, right?
Mm-hmm.
So that, all that being said, is that it's generally a good idea to get a registration early. And as I might say again, the benefits of registration are more than just the evidence. It's also that it gives someone the ability to sue for additional damages. So there's damages that one can get. The damage in a lawsuit. In a lawsuit, the damages are what are any monetary gains that someone may have gotten, that you were supposed to get that money, let's say, and someone else stole the idea and they got that money instead. So that would be general damages. But there's also statutory damages, because these are all covered by statutes. And in order to get the statutory damages, which is a higher level of a monetary payment, you would have to register the copyright. So, and you could also get attorney's fees. So without that copyright registration, those additional kind of prizes, right, potentially are not available to the copyright holder in that case. So it's important to obtain the registration. And if one doesn't, you do have remedies to pursue. You could pursue the case. You could file the registration after the fact. But again, the issue is that there is a chance that the registration won't be allowed. There's a chance that you won't get that piece. So I always tell my clients, you should file the registration as early as you possibly can.
Okay. And one thing that I've written a couple books, and my most recent, the Mashpreneur Playbook, is something that I use as sort of the framework for everything I do when I'm working with entrepreneurs and business owners. So, I've got the book copyrighted. So does that mean everything that's in the book is copyrighted, or should I copyright some other things? So, for example, I created like the 5 steps in the Mashpreneur path, going from working on the concept of your business, to working in your business, to working on your business, to working on the future, to working on scaling your business. And is this something that I should copyright secondarily, or is it okay just that the book is copyrighted and this is laid out within the book?
So when you copyrighted your book, everything in the book is copyrighted. So you wouldn't have to then copyright this portion, the 5 steps, separately. You wouldn't have to do that. It would fall within the copyright of that book. I don't see a need to copyright it in a sort of a secondary copyright, unless, for example, it's sort of a standalone piece that you feel that it can actually be its own copyrightable entity. But again, I don't see a reason, because if it's in the book, it's part of the copyright. I alluded to this idea called fair use before, where someone might be able to pull out like a snippet of your book or a piece and just use a piece of it, because that might be called fair use. But it really doesn't apply. It only applies if the work has been changed enough. A lot of times people will use works for satire. Satire can be considered a fair use if it's clear that it has nothing to do with the original work. It's totally different. It's not going to be confusing, that you might confuse it for the original work. So in this case, I don't see why you would why you would need to do that. It's copyrighted as part of the book. You registered your book, and so everything within the book would fall under that copyright.
Okay. All right. So good to know. But you said if I was use it as a standalone, possibly use it as a copyright or maybe even a trademark. Okay.
Yeah, absolutely. The trademark would be a little bit trickier because it could be a trade name, a logo, or an expression. So you could actually get a trademark maybe for the entire piece and how it looks, and it's like a logo, or you can break it up into each piece. But to get a trademark would be a little bit trickier. It's doable. It is doable.
Mm-hmm.
But yeah, as far as the copyright goes, if it's a standalone piece that you would like to obtain additional protection, again, not necessary, but it's like it's more of the idea that this is sort of your most creative expression, and you want to give it that additional protection just in case someone takes it. Because a lot of these things are a little bit of gray area, Andrew. I'm talking about fair use. The law on fair use has developed a lot, and it's a little bit gray. It's not so clear what it means, how it can be applied. So just to answer your question, there's always degrees of let's get more protection. So you have it in the book. Okay, is that enough? This is really important to me. This is my business. This is it. Then you go to the next part. Well, okay, you can get a copyright on this. You can get a trademark on these things too. And we started talking about how to do that, but you've already had a session on trademarks,
Right?
But it has to be used in commerce. So that's the one caveat with the trademark.
Okay. So, one thing that they used to always say is, I guess the poor man's copyright was, you get your document and you mail it to yourself. Does that work, or is that just like, the old days, or, what was that all about?
Well, it works in a way, right? As we were talking about how you don't even need to mail it to yourself, and you don't need to email it to yourself. In fact, you could just leave it on your desk, and it's a work of art. It's created automatically. But when you mail it to yourself, that's evidence now that, okay, there's a timestamp, there's a date. Maybe the post office gives it that additional evidentiary seal of approval. If you emailed it to yourself, now you have a timestamp right through your email, and through Google, through Gmail, or through other email sources that have metadata, and it can be tracked down. So when you're proving that, oh, I wrote this on such and such a date, to say I'm the original author, it gives someone that ability. But it's nothing more than a creation of art that has some evidence as to when it was created, and that the author is the original author. But in terms of the registration itself to give any of those protections that I spoke about,
Mm-hmm.
statutory damages, attorney's fees, those are not available. So is it the poor man's copyright in a way? Yes, but not really, because it doesn't really provide any benefit over, let's say I write something in Word and I save it. Now it's a timestamp, it has that date, and everything's there. The only benefit is that it gives you additional evidence, right? Because to the extent that a jury or a judge might say, well, you just that date is not certified, right? It's not a certified date. Well, if you send it in the post office and they certify it in the mail, then it's certified, right? It's certified by the government, and that gives that additional certification to that date. So that could be the point there, is that it gives it that stamp of a date and a timestamp, which is critical in intellectual property, because it's all about a race to the office. Whoever files first has the idea first. And so it's trademarks, copyrights, and patents. They're all about a race to the office, to file first, and then ultimately to get the registration. But even without the registration, right, for copyrights only, actually trademarks also, we can talk about that too. There's an idea of a common law copyright and a common law trademark, where just like in copyright, whenever you create your idea, your book, right? Now it's in form, and it's copyright. The copyright is automatic. Similar idea in trademark. Let's say I have a trade name and I start selling. Let's say, Andrew, you start selling your SB Pro University name, or a product, or let's say a course or something, and it has that trade name on it, and you didn't register the trademark. You didn't do that. But guess what? The day that you started selling SB Pro University classes, that's a common law trademark. You just established it because you started using that name, brand new name. No one's ever used it before, in commerce. So when you started using that name, you started in commerce and selling something associated with that name. That's called a common law trademark. And now, similar to the copyright idea, if someone steals your idea, you can then sue them in court and say, I was doing this first. And to prove that, you would have to then go online, maybe the Wayback Machine, to say, look, I had this website, SB Pro University, and it had you could buy the course right here, and this is the link, and you could backtrack it to such and such a date. But again, without that seal of the governmental approval, you would have to then prove up all of these components using evidence as much as you can. And if all the evidence you have is maybe your own little date that you scribbled on the side of the notepad, I'm not sure that's going to hold up.
Okay.
In a court of law. Yeah.
Okay. And you said there's a race. So if someone gets to the patent office first and files, but you were there, you did it first, how does that work out?
Are we talking about patents now? Switching gears?
Patents or copyrights,
Okay.
or is it the same, or is it different for different things?
Okay. Well, that's great. It is the same. So once you file your patent application or copyright registration, it's a filing that has been made in in this case, the Trademark and Patent Office, United States Patent and Trademark Office, the USPTO, and then there's a separate office, which is the Copyright Office. For some reason, they're separated. But once you file it, you're good. You've won the race, so to speak. So as long as no one else has come up with this idea, and it's not somewhere else in the what's called the prior art, which is the art that came beforehand, right? It's a new thing, it's a new idea, it's a novel expression of art, it's a novel authorship, it's a novel invention, and you are entitled to that priority date. That's your priority date. You have the priority. You have you're first in line. You made it to the office. And you won the race. Now, as long as everything is there and your invention is solid and everything is complete and it's good, then you have nothing to worry about. If there are issues with it and you have to add to the invention and it wasn't finalized yet, that's when things can get a little bit complex, because you're going to be working against what you've already sort of filed, and you've already kind of exposed it to the public in a way. Now, when you file a patent application, you have two options. You could file a provisional application, which gives you that full year. It gives you a year of working on your patent to make things good and work out the kinks and start selling it. And it gives you that priority date. So if you're not sure, if your invention is going to, I say this because a lot of people are not aware that you have this option, because when you obtain a patent, it's a lot more expensive than going for a copyright. It's a lot more expensive, and it's actually only 20 years of protection from the filing date. So it's a shorter period of time than a copyright, which is 70 years after the death of the author. But the reason being that patents have a lot more potential to influence the market in terms of technology. So because technology is rapidly changing and advancing, the statute has been set at 20 years. And that's the incentive to make things kind of run. And it gives patents, which are very, very valuable, a time span, a life. And there's a whole field of law called patent life cycle management, where people are constantly trying to obtain additional patents to sort of enhance the lifespan of a product. So that's why there are these patent law, and we haven't spent much time talking about patent law in this conversation, but it's actually a lot more intricate and complex, and there's different kind of aspects to it that one can dive in much deeper into patent law. But again, to your question, I want to be very specific with your question. When you get to when you file it, you have this priority date. That's why I always encourage to file early. File your patents early, file your trademarks early, file your copyrights early. The only caveat is if your invention is not complete yet, in which case you may want to file a provisional application, which gives you that priority date, and it gives you a full year to then optimize the conditions, do testing, sell the product, and see if this is something worth pursuing. And that's the more economical way. But if you are 100% sure that your invention is good and solid, definitely file what's called a non-provisional application and skip the provisional aspect altogether. It's only for those maybe not so uncommon circumstances when the invention is sort of it's there in theory. It's just all the kinks haven't been worked out, and that gives my clients additional time to do that with confidence and certainty that they already have that date locked in.
Okay. No, that's great to know. So now, we did cover a lot on copyrights, and patents. There's like a whole bunch of directions you can go, but the first thing, if you think you should be filing a patent, what do you need to have, or where do you need to be, and also what should you do?
Sure, Andrew. Appreciate the question. So when an inventor wants to obtain a patent, it's going to require a formal application with the patent office, including a detailed description of the invention, claims defining the scope of the invention. And so, as I said, patents, they protect these new, useful, and non-obvious inventions or discoveries. So the inventor is going to want to draft up some kind of invention disclosure and share that with a patent attorney, and either do that or make sure that the patent claims and all of the figures are proper. But the first thing to do is to really obtain a patent counsel. Patent counsel will assist with the intricacies of the filing and all sorts of pitfalls that could happen during the patent drafting process. So it's really important to obtain patent counsel early on, and to work with a patent attorney, a registered patent attorney who can communicate with the patent office and make the filings, and do it with ease and such that to ensure that the patent can be filed, we can get the priority date, and that everything should be proper. There's also a requirement to disclose all information that is pertinent to the invention. So whether good or bad. So if it's bad, you're required to disclose it. If it's good, you should disclose it. So it's important to take notes and to make sure that things are properly accounted for in terms of what's known in the art. There's also something called an invention disclosure form, which requires the inventor to disclose any prior art that's relevant that they may be aware of. So getting all of these materials together, then beginning the drafting process and drafting the figures and putting it all together, that's what an inventor should do immediately when they want to obtain a patent. So is to sort of get all the ducks in a row. All the information should be organized and compiled in one spot, and obtain patent counsel to properly pursue the invention in the proper way.
Excellent. So, okay, so definitely on a patent, we're going to want to get some help. Copyright, I guess, initially, if you're going to file it, that's something you should just do yourself, or should you get an attorney to do that with you? And then I know a trademark you can do yourself, but you can miss some things, so that might not be good to do yourself. What are your views on those?
I think that's right, Andrew. I think that for solo inventors, for entrepreneurs who may not have the funding necessary to obtain counsel, there are cheaper options. That first of all, you could file the registration yourself, the copyright registration, certainly. Now, for trademarks and patents, it's a little bit trickier, because that's why we have patent agents and patent attorneys, who are actually take another bar just to communicate with the patent office itself. So a solo entrepreneur or a business owner could file their own patent and could file their own trademark. It's definitely doable. The initial stage, the initial filing, they could do it themselves online. Not super easy to do. But once you file it, anything that comes after, you're going to need an attorney for, or a patent agent for, someone who actually took that test and got sworn in by the USPTO. So you need someone to then take that application, because typically it's not going to go straight through.
Okay.
Most of the time, there's a rejection that comes back. Most of the time there's a rejection. It could be for one of many reasons. Some of which I mentioned, right? Maybe it's not, maybe they consider it obvious. Maybe there's a problem with the way it was written. The written description requirement isn't met. So when the application is then rejected in an office action, an attorney or an agent would be needed to then reply to that office action at that point. So it generally helps to have an attorney from the beginning, helping you get to that point. But if someone just cannot afford the patent, also there are some attorneys who do patents pro bono. So I would reach out and try to. I'm happy to make connections and help people find pro bono services as well. So for those people listening, I'm really I'm aware that these things can be very expensive, and I always provide a free consultation. I'm happy to talk to people anytime, just because I find this so interesting and fascinating, and helping and protecting people, especially small businesses, is really important to me.
Okay, excellent. So, okay, no, that's hugely helpful. So, definitely, let me just make sure everybody knows, but we've got your website. So if they want to see a little bit more about you and your firm, you can check out Benjamin's website. Also, if you want to just know a little bit more about Benjamin and connect with him on LinkedIn, he's there as well. So, we're coming up on the hour. And before we go, I always like to ask guests, what are the 3 key things people should take away from what we talked about today? Because many times people can't remember more than 3 things. And, it's easier to focus on the, 3 things, because we did talk about a whole bunch of stuff that can be taken away from it. But what is it, most important that people should take away? So I'll give you a minute to sort of think about that. And I'll share a little bit about our upcoming event. On November 8th, we're going to have our next Power Breakfast. It's going to be at the Park Avenue Club. And we've been doing them for over 12 years and, have great results. A few times a year, we'll do events and gatherings for entrepreneurs and business owners. So that's the next one, our last one for 2024. So hopefully you can join us. And here's a short video that tells you a little bit about, what the Power Breakfast is all about. If you are looking to increase revenues, improve profitability, and or obtain financing for your business, you need to check out the Power Breakfast and Small Business Pro conferences.
My name is Andrew Frazier. One of the things we're here to do is supercharge your day.
Today's Power Breakfast has really been a phenomenal experience. I think it's exactly what business owners need, some true guidance of people who are genuine and really are leading them in the true direction of business growth and expansion.
The Power Breakfast is so important for the entrepreneurial community because it gives the various business people who come together an opportunity to interact and also do some business.
These events, hosted by Andrew Frazier, President and COO of Small Business Like a Pro, will supercharge your day.
Okay. All right, great. Welcome back. I'm here hanging out with Benjamin Dach. We're talking small business. We spent, about an hour chatting about, really how to protect your business in terms of copyrights, in terms of patents. Of course, we could talk for hours and hours, but, nobody wants to be here for hours and hours. So we're just going to keep it to this, but definitely, we want to make sure you get the most out of it. So Benjamin, what are the 3 key things people should take away from what we talked about tonight?
Sure, Andrew. Andrew, I want to say thank you so much for having me. This has been a blast. Just to keep it real simple, 3 things. First, keep notes. Keep track of what you're doing and all of the ideas. When were they conceived? Keep diligent notes and keep organized. That's number 1. Number 2, file early. So make sure that you get your copyright and or your patent filed as early as you possibly can while maintaining quality. And number 3 is obtain counsel. Don't be afraid to reach out to an attorney, even looking for pro bono work. There are plenty of resources out there that can help you. So those are my big 3 takeaways. Keep organized, file early, and don't be afraid to reach out. Thank you so much, Andrew. It's been such a pleasure.
Okay, well, thank you, Benjamin. That's great. I mean, definitely, a lot of times we don't even think about keeping notes and keeping track of stuff. But, especially in this case, those could be extremely valuable. File early, so don't procrastinate. And, as a small business owner, I got like a list of this many things. So, you always, a lot of times don't take care of the stuff that's important, but not urgent. But that's just another reminder that patents are very important, or trademarks or copyrights. So you don't want to just leave them on that list forever. And obtain counsel. It could be scary because lawyer fees can be a lot, but it doesn't have to be. At least talk to someone. Maybe you can get pro bono. Definitely. You don't want to go through the process and mess up and not be protected. That's so. No, this has been great, Benjamin. Thanks so much for taking your time out to kind of hang out with us. Definitely appreciate you sharing. If you can, hang on for a minute as I close out, and we'll chat for a minute afterwards. Cool. So, okay. So, once again, great show. It's been good talking with Benjamin. I think, hopefully you learned something. I learned something myself as well. And that's one of the reasons why I enjoy hanging out. So, always appreciate people tuning in. Also, we know it's right after the Labor Day holiday. So hopefully you had a good holiday. You're getting back to business. Things are going to be speeding up the mad dash to the end of the year. So, definitely encourage you to wish you much success with that. And, we can hopefully help you to, like what we do, help people sell more, maximize profit, and finance their business growth. So next week, our guest is Suzanne, and we're going to talk about increasing your LTV by knowing your customers better. So I'm not going to tell you what LTV is today, but hopefully you'll join us next week and you'll get a chance to learn about how to increase your LTV by knowing your customers better. So, thanks again for tuning in. Always appreciate everybody joining us. And those of you who couldn't join us live, join us online for YouTube, LinkedIn, Facebook for the recording. But we also go out over the, we go out through, let's see, let me just pull it up here. We go out through the metaverse. We're on Small Business or STEM City USA, broadcasting in the metaverse as well. And then in about a month, this episode will come out on the podcast as well. So always remember that at the end of the day, the more that you know, the more successful your business is going to grow.
Thank you for listening to Leadership Live at 8:05, Talking Small Business. Subscribe to our YouTube channel and to the podcast on your favorite podcast platform. Leadership Live is one of the many valuable resources provided through the Small Business Pro University, empowering business owners to learn, profit, and grow. Find out more at sbpro.u.com.